Hello and welcome. My name is Danish Nafay and I am an information security consultant. Welcome to Evidence Types. Forensic science is generally defined as the application of science to the law, while digital forensics is the application of science to the identification, collection, examination, and analysis of data while preserving the integrity of information and maintaining a strict chain of custody. Once the evidence is collected, it can be categorized in multiple ways: real evidence, documentary evidence, testimonial evidence. Real evidence is also known as object evidence. It consists of objective items that will be brought into a court of law. In common criminal proceedings, this may include items such as murder weapon, clothing, keyboard with fingerprints, hard drives, or other physical objects. Real evidence is considered to be the strongest evidence, and depending on the circumstances, real evidence can be conclusive evidence and often undeniable, such as DNA. Documentary evidence includes any written items brought into court to prove a fact at hand. This includes contracts, SLAs, NDAs, and other documents. This type of evidence must be authenticated. For example, if a lawyer wants to present computer logs as evidence, they must bring a witness, for example the system administrator, into court to testify that the log was collected as a routine business practice and is indeed the actual log that the system collected. Two additional evidence rules apply specifically to documentary evidence. The first rule is the best evidence rule. The best evidence rule states that when a document is presented as evidence in a court proceeding, the original document must be introduced. Copies or description of original evidence, known as secondary evidence, will not be accepted as evidence unless certain exceptions to the rule apply. Another important rule is the payroll evidence rule, which states that when an agreement between two parties is put into a written form, the written document shall contain all the terms of agreement, and no verbal agreements may modify the written agreement. For example, an SLA has been signed to have the network uptime to be 98%, and after signing the SLA, both parties verbally discuss to increase it to 99%. This will not be considered in a court of law. The court will only consider the signed SLA. The payroll evidence rule is often underestimated, but could be decisive and of utmost importance in many cases. If documentary evidence meets the materiality, competency, and relevancy requirements, and also complies with the best evidence and payroll evidence rule, it can be admitted into a court of law. Testimony evidence is quite simply evidence consisting of the testimony of a witness. As you may have seen in many movies, witnesses take an oath agreeing to tell the truth, and they must have the personal knowledge on which the testimony is based. Witnesses can offer direct evidence. Oral testimony proves a claim based on their own direct observation. The testimonial evidence of most witnesses must be strictly limited to direct evidence based on the witness's factual observations. However, this does not apply if a witness has been accepted by the court as an expert in a certain field, which is called expert opinion. In that case, the witness may offer an expert opinion based on the other facts presented and their personal knowledge of the field. Courts have frequently referred to IT professionals' expert opinion on a number of occasions. Testimonial evidence must not be hearsay evidence. Hearsay evidence means a witness cannot testify as to what someone else told them outside the court. Computer log files that are not authenticated by a system administrator can also be considered hearsay evidence. This is the reason date and time stamps, source and destination systems, as well as the chain of custody for evidence is so important. What are some evidence nightmare stories you have heard of? What is one practice for collecting documentary evidence in your organization? Do share with us. Till then, goodbye.